As your viewers may know, Christopher Ram, a private citizen, as well as Vishnu Bandu, another private citizen who happens to be the leader of a political party, filed two separate challenges under the Constitution, challenging the electoral system of Guyana, and in particular, challenging certain sections of the Representation of the People Act. In short, they both claimed that the court should set aside certain sections of the ROPA, as well as the court should declare unconstitutional certain aspects of our electoral framework. So, to explain the two cases, I may have to go one at a time, because they were nuanced a little differently and presented on different principles. So let's start with the Christopher Ram's challenge. Mr. Ram argues that Article 160 provides for a candidate as opposed to a list of candidates to contest the elections, and that Parliament never gave effect to that aspect of Article 160 because ROPA, which is the effective legislation in relation to elections, provides only for a list system. And insofar as ROPA does not provide for a candidate to function independent of a list and to contest the elections, ROPA is defective and ROPA is inconsistent with Article 160 of the Constitution. And that makes the electoral framework unconstitutional. And he's asking that the court should declare those sections of ROPA as unconstitutional, and basically GCOM must allow an individual to contest the elections outside of a list system. Now, we countered that his reading of Article 160 was completely inaccurate. Article 160 makes no provision whatsoever for an independent candidate to run. Article 160, first of all, entrenches in the Constitution and establishes an electoral system called proportional representation. Proportional representation by itself, by its very character, does not allow for independent candidates to run. So that's the first flaw in the argument. Systemically, Article 160 could not have provided for what he says it provides for, because the system that Article 160 creates, the electoral system, is a proportional representation system which does not allow for independent candidates to contest. That's the first point. The second point is reading Article 160 in its entirety clearly stipulates that only a candidate can only run if that candidate is part of a list system or is connected to or associated with a list of candidates. There is no single candidate that can run by him or herself, and nowhere in ROPA, in Article 160, says that. They completely misconstrued Article 160. They plucked words out of it to suit their political expedient position in their cases, in the case. And we had to show the court how Article 160 should be interpreted and how the proportional representation electoral system works. And we refer to many cases decided by our court system over the years where the system, the electoral system, was examined, interpreted, interrogated, inspected, and found to be democratic. Because one of the arguments that they were advancing is that Guyana is a democratic state, and that by the Constitution not permitting individuals to contest an election makes the electoral system, and by extension Guyana, an undemocratic state. And we had to point out that all over the world there are different electoral systems. You have systems where only party lists are allowed to contest an election, and that largely takes place in a PR system. And then you have first past the post, where you have individuals who can contest. Would the reverse argument work? Can anyone argue that all the countries that have a first past the post system, which really is the whole of the Caribbean, can one argue that the entire Caribbean the system is undemocratic because it doesn't permit a list system? It only permits an individual to contest the elections. So the arguments were deeply flawed, and we were able to persuade the Chief Justice that the case has no merit, and eventually the case was dismissed.
You mentioned... Okay, go ahead.
And the Chief Justice awarded costs against Christopher Ram in the sum of 500,000. Now, Bandu case was a slightly different. Bandu case begun with Roysdale Ford representing him. Roysdale Ford argued first that the structure of the Guyana Constitution was wrong, and that the structure of the Constitution was undemocratic. I think good sense prevailed somewhere along the line, and he abandoned that argument. And he then focused on Article 147 and 160 of the Constitution. And his argument essentially was that Article 160 permits a political party to contest the elections. Article 147, he says, guarantees his client a fundamental right to participate in an election in any manner that he feels. However, provisions of ROPA restricts his clients to a particular way, because ROPA says that you can only participate in the elections in accordance with the provisions of ROPA. For example, apparently Mr. Bandu wants to contest only one seat, and ROPA mandates him to contest a minimum number of seats before he can qualify to contest the elections, period. And Bandu is arguing that, look, I have a fundamental right to belong to a political party and to contest the elections. And that political right that I have is a fundamental right. And he sources Article 147 as the basis that gives him that political right. And he says, look, if I can't contest this election in the manner that I want to contest it, then my political rights guaranteed to me by Article 147 of the Constitution is being violated, or are being violated. So we went to Article 147 and we clinically examined Article 147 for the court, word by word, word for word. And we were able to show very clearly that while Article 147 guarantees freedom of association and freedom to be part of a political party, freedom to belong to a political party, freedom to belong to a trade union, freedom to strike, and a whole set of other things, it does not permit in any form or fashion the right of a person, or doesn't confer the right of a person to participate in elections. And that's what Mr. Ford is saying, that he's enlarging the right to form a political party and a right to belong to a political party to include a right to contest elections in a manner that he wants to contest. And that is enlarging the language of the Constitution beyond what the drafters intended. Now, if the drafters intended to confer that right, then the drafters would have said so, would have said expressly that you have a right to participate in elections, and to participate in elections, I suppose, how you wish or how you deem fit. Parliament stopped short. It says you have a right to belong to a political party and you have a right to form a political party. Now Bandu belongs to a political party and Bandu has formed a political party. So those rights that Article 147 confer upon him are not violated. And he doesn't say that they were violated. He goes an extra mile now. He says, not only must I belong to a political party, not only must I form a political party, but I must be allowed to contest elections in a particular way. And ROPA is not allowing me to do so. And insofar as ROPA restricts my right to contest the election in the manner that I would like to contest the elections, ROPA is restricting me from doing so. And we were able to show the Chief Justice very clearly that Article 147 doesn't say what they are saying Article 147 says. Article 147 stops short. And then, so that was clear. Article 147 did not give him the right that he's claiming that Article 147 gives him. So that part of his case was struck out. And then he then began to rely on a covenant that we signed, the Covenant on Civil and Political Rights. That covenant has a provision that speaks to the right to participate in an elections. And he's arguing because we signed on to that. One provision in the Constitution says that you must take into account all of our international conventions when you are interpreting the Constitution. But the Constitution also says that if one of the rights in those conventions are part of the fundamental rights provisions of the Constitution, then those conventions are not applicable. Because, and I explained why. If you see, if you were able to allow international conventions to be used to amend the Constitution, then a government who doesn't control a two-thirds majority in the Parliament can sign on to a convention and amend the Constitution without going to the Parliament of the country and getting a two-thirds majority which is required by law. And that would be an unholy way of amending the Constitution through a backdoor methodology. And the law will never permit that. The Constitution remains a contract between the people and the state. And the Constitution says that in order for it to be amended, in most of the provisions, 2/3 of the people's representative in the Parliament must vote and say that they want that amendment. Now imagine a government is authorized and doesn't enjoy a 2/3 majority to enter into a treaty, and then that treaty now, in a backdoor fashion, is allowed to amend the Constitution. The Constitution will never permit that, and that would be wrong in law. And that is what Mr. Ford is inviting the court to do. And I think that I was able to persuade the court not to travel that road. It's a dangerous road to travel. But in any event, the court eventually found that that provision of the convention was not enforceable. It simply is a guide for countries to take into account when they are crafting their electoral systems. And all countries are influenced by it because it's a 1967 convention. We obviously took that into account when we constructed our particular electoral system, because every citizen has a right to vote. Every person has a right to participate in the elections as a political party leader or as an elector. But you simply have to comply with the rules. No constitution in the world or no country in the world has elections that are absolute in nature, where you can do anything. Elections by their very nature have to be regulated. You have to have, for example, a voting age. Not every person can vote. You must have disqualifications and qualifications to vote. And you must vote in a particular manner set out in the relevant legislation. How else will you conduct elections in an orderly way? So that provision in the that convention that Mr. Ford is relying on applies to Guyana, yes, and we have taken it into account. But that provision cannot be used to undermine our electoral system. We have satisfied the conditionalities of that particular covenant by ensuring that we have designed a system that allow every single Guyanese, once they reach the age qualified to vote, and every single Guyanese to contest an election as a political contestant, provided, of course, that they meet the qualifications to contest. So the court in the end dismissed Mr. Bandu's application as well, found it to be without merit, Mr. Ford used all types of cases, as he normally does, from Canada, from Africa, from South Africa. And I continuously tell the judge that these cases are determined in accordance with the peculiar electoral framework and constitutional matrix of that particular country. So they're not helpful in determining an issue that arises in Guyana. We have our peculiar constitutional construct, our legislative framework, and our electoral system that has been interrogated many times by our courts. And we have enough learning here. Why are you going to South Africa on a peculiar issue like this when there is, the two situations are not on all fours? They're not parallel to each other, right? So eventually we were able to persuade the Chief Justice that both applications were frivolous and vexatious and without merit, and they were both dismissed with costs being awarded. In terms of Bandu, he has to pay $250 to the EG and $250 to GCOM, and Christopher Ram has to pay $500,000 to the Attorney General.
Let me ask you, AG, what do you make of these particular applications? Do you think that there is an ulterior motive attached to them coming to the court, especially at this time?
Well, this one was clearly intended to delay the elections, I think. I think that was the driving factor behind it. But when it reached the court and when you start to read it and the case began, I think that intention dissipated quickly because they realized that when they read our answer and our submissions, I believe they felt quickly that they can't achieve that objective, that the case was not going to be decided. And we managed to persuade the Chief Justice to determine the case long before the elections so that, one can't say that we have this hovering over our head going to the elections. So all's well that ends well.